One of the most important provisions in any ERP contract is an indemnity provision. What is it? What should you ask for? What's reasonable? And what should you expect? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney, and for the last 20 years, I've been drafting and negotiating ERP-related contracts and litigating failed digital transformations in courts across the country. An indemnity provision in an ERP contract generally refers to the broad concept of one party to that contract compensating the other party for losses, damages, or liabilities, which are usually due to some sort of a third-party claim. And when you're negotiating an ERP indemnity provision, you want to think about the scope of that indemnity obligation, the limitations, what are the triggering events, the types of losses that are going to be covered by that indemnity provision. Those are all negotiable. But I think the guiding light for this really is that all of these negotiable aspects of an indemnity provision really need to align with the unique risks of that particular transaction. And it's going to depend on how much money you're spending, what kind of functionality you're licensing. Is it a software license, a SaaS agreement? Is it an integration or implementation agreement? All of that is going to become relevant. And generally, as you talk about these things and you conceptualize an indemnity provision in the context of an ERP contract, you're going to want to customize the amount of risk that you're willing to undertake in each transaction with that ERP vendor. And the goal of the indemnity provision really is to allocate the risk of the transaction to the party that really has more responsibility for bearing that risk. In the context of an ERP contract, an ERP vendor is typically going to provide certain types of representations and warranties. And I think some of the more important ones that directly relate to an indemnity provision are going to be warranties around ownership, non-infringement, warranty of good title, or authorization to grant you access to the software or the functionality that you're being provided access to. And the question is, and whether the indemnity obligation comes into play, is what happens if those warranties are breached? And I think it is going to be typical for an ERP vendor, and something you should ask for, is for that ERP vendor to indemnify you, to defend you, and to hold you harmless against any third-party claim alleging that your use of that technology is damaging a third party because your use is infringing. And so, the triggering event in that sort of a scenario is going to be the infringement or the misappropriation or whatever it is that constitutes your use of that technology. And so, what's negotiable is it going to be the triggering event? Is that going to be a claim for infringement? Is it going to be an allegation of infringement? Does the indemnity obligation kick in when there's actually a lawsuit filed? Does the indemnity obligation kick in if there's a demand letter that is sent to you that you've got to respond to? Again, all of this is negotiable, and I think as a customer, you want to have the broadest indemnity provision that you can reasonably negotiate, bearing in mind the risks of the transaction. So ideally, you're going to want to have a broad triggering event that's going to include, something along the lines of, any allegations or claims associated with the infringement or misappropriation of any, third-party intellectual property right, versus something along the lines of, say, the filing of a lawsuit asserting copyright infringement or patent infringement or trademark infringement. That's a much narrower type of triggering event. One of the other things you've got to think about is what is the scope of the indemnity obligation? And once that obligation is triggered, what is the obligation of the ERP vendor to do? Are they going to defend you? Are they going to hold you harmless? Are they just going to pay damages or attorney's fees that are finally awarded by, say, a court of competent jurisdiction? Again, that's a much narrower scope, and I think as the customer, you're going to want to have the broadest scope that you can possibly negotiate. One of the things that you really need to be aware of as you're going through these types of provisions is what are the exclusions? What are the exceptions to that obligation? And I think it is incredibly common for ERP vendors to have broad-based exclusions that negate their obligation to indemnify you, and they can be so broad that they really can make that indemnity obligation meaningless, and that's something that you've really got to watch out for. And so, for example, there will be an exception to the indemnity obligation to the extent that you are using the software in a way that is inconsistent with the intent of the agreement, whatever that means, right? There will be an exception to the indemnity obligation to the extent that your use is infringing. Again, it's not really clear exactly what that means. And if there are exceptions to the indemnity obligation, you need to make sure that they're narrow. You want to make sure that they read on or have some relationship to the claim that is giving rise to the indemnity obligation. So there needs to be a one-to-one. If, for example, if I'm using the software with software that was not provided by the ERP vendor, why would that negate the vendor's obligation to provide me with an indemnity obligation? That exception needs to be narrower. And so to the extent that my use of the software for that third-party product caused the issue giving rise to the indemnity obligation, that starts to become more of a reasonable scenario. So I think the variations and the nuances to these provisions are pretty complex, and when you're dealing with negotiating these, I think it really does make sense to have somebody on your team that is familiar with these and has seen them before, because the risk of getting it wrong is incredibly high, and that's not a position you want to be in. If you have any questions about any of the issues discussed in this video today, please feel free to reach out to us at taftlaw.com. We'd love to talk to you about this.